Hello, everyone, and welcome back to yet another session on polity and constitution. I hope I'm audible as well as visible. Great. Let's wait for others to join and then we'll begin our discussion for the day. Oh, thank you, Ankit. Thank you. Okay, so let's do a quick recap. In the meantime, others will keep on joining. So, as far as yesterday was concerned, we had taken up for discussion topics like, we started our discussion on the topic collegium. I explained the collegium, what is the collegium for Supreme Court, what is the collegium for High Court, what is the collegium for transferring judges from one High Court to another. All these things were discussed yesterday. Then we moved on and we also tried to understand what were the other provisions pertaining to, say, removal of the judges, also salary, oath, then Article 124, Clause 7, which debars the Supreme Court judges post-retirement from pleading or acting in any court of law in the territory of the country. Then ad hoc judges, retired judges, court of records, and always remember two special features of court of records: they can review their own decisions and they have power to issue contempt. Then Article 130, seat of Supreme Court, then Article 131, original jurisdiction, which basically means that some kind of cases can only be filed in Supreme Court and can directly be filed in Supreme Court. Meaning you cannot go to any court to file a case, but only to Supreme Court and directly to Supreme Court, right? So if there is any dispute pertaining to elections of president, you cannot go to your local court, high court, etc. You have to go to Supreme Court only. Supreme Court only, exclusive, original jurisdiction. Then we also saw appellate jurisdiction, the entire structure of how the cases are appealed in the Supreme Court. And if High Court denies certificate or the case is not fit, then we also have the opportunity of a special leave petition, SLP, Article 136, then revisory jurisdiction and a concept called curative petition. Now, no, Anshu, Supreme Court does not have a single judge bench. They only have division benches. That is minimum 2 judges. Single judge bench is in High Court. Of course, lower courts function as single judge bench only, but High Courts have single judge bench as well as division bench, which means 2 judges. And sometimes when there is a matter which involves interpreting the Constitution, then it has 3 judge bench. Leave, I mentioned yesterday, leave means permission, special permission to file a petition in the Supreme Court. Okay. So that is called SLP, special permission taken from Supreme Court to file a case in Supreme Court when High Court does not give you a certificate. That is called special leave petition. Finally, we saw the remaining provisions under Supreme Court: advisory jurisdiction, Article 139, 39A, 141, and then judicial activism, 142. And then 145. 145 deals with what? It deals with the rules of Supreme Court and the bench's size, the size of the bench which is required to interpret the Constitution has to be at least 5. That's it. Now we saw high courts again. The case of appointment, removal, it's exactly the same. Salary allowances, pensions, all these things, plus of course qualification to be a judge in the judicial office. If you're holding a judicial office, that means if you are a judge at the lower level, then you can become a judge in the high court. 10 years of judicial office or 10 years of being an advocate in the lower court, advocate in the high court. That also is a criteria which makes you eligible to become a high court judge, subject to the recommendation of names of the high court collegium to the Supreme Court collegium. And then the Supreme Court collegium is the final authority to decide on these matters. Then the lower courts, the entire structure, session side, civil side. Then topics like NALSA, judicial independence. Then we saw pendency of cases, reasons, solutions, suggestions. Then Lok Adalats, Gram Nyayalay. And then the last topic I believe was All India Judicial Service. So that is with respect to the topics we had covered yesterday. Okay. So let's see what questions do we have. Curative petition, Kanak. I had explained, I think, very clearly yesterday on what is the meaning of curative petition. It is just like I did also explain to you in your personal case. If you have ever taken an examination in school or college, your marks were evaluated, and you went to the professor or teacher again for re-evaluation. That is called review petition. But suppose even after re-evaluation you are not satisfied and you want to go again, right? Said, sir, please re-evaluate, re-evaluate. That would be called curative petition. If somebody is not satisfied with the judgment of review petition, he or she can ask the Supreme Court again that, sir, can you please take out some time and look into my case? That is called curative petition. Okay. Recusal. Recusal, Anshu, basically means if I am, say, friends with a particular party or litigant in the case, let's say there are two people who have come to me, and one person, Mr. A, I have known him for a long period of time. Maybe he owns a company, and when I was a lawyer 10 years back, I was a lawyer for his company. Maybe he's a family friend, maybe he's a family enemy. So the moment you know any of the parties, then the judgments may not be fair. So in such situations, I'll take back my name. I'll say, I cannot be a part of this bench. Chief Justice, please pass this case to somebody else. That is called recusal. Okay. Yes, Shiva, setting up multiple benches, of course, is a very good option. We'll not use branches, we'll use benches. That's an appropriate word. Of course, but then Supreme Court has shown no interest in setting up multiple benches. Ajit, that's true actually. According to Niti Aayog report, it's not, I mean, see, they gave that particular statement in the context of 2018. So if we overcome those issues, for example, hire more judges, right, fast-paced delivery of justice, etc., then things can improve. But if we don't make any kind of change whatsoever, and the change is very slow, we'll only end up no, with more and more pendency. That's the case. What else do we have? Anshu. Sir, judgment by 3-judge bench of High Court after single judge bench and appeal. No. Single judge bench, you go to division bench. You don't go to 3-judge bench. 3-judge bench is only meant for constitutional matters. if there is a constitutional matter, then we go to a 3-judge bench, right? So that is possible. If the Chief Justice directly says, please go to 3-judge bench only, then that's possible, right? So there is no constitutional mandate that you have to go to a single judge bench, then to division bench. It all depends on the Chief Justice there. That is why we say that the High Court and Supreme Court, they make their own rules on how these things function, right? So the rules are subject to changes based on the opinion of the Chief Justice and the situation at that point of time. Kajal, habeas corpus will discuss under fundamental rights. Article 32 will discuss habeas corpus at that point of time. Okay, so today Anshu has a lot of questions. Either you have revised properly or you have not attended class yesterday. So erosion of image. I mean, see, the point is, if you have not taken your task sincerely, like say police, if police is involved in corruption, don't you think that their image erodes, right? Like erosion, soil erosion, image also erodes. The credibility of a person comes under a lot of scrutiny if they don't perform well. If you are given a task, right, then what happens? You are given a task and you fail to perform the task regularly, every time, then you may not be able to hold the same credibility in other people's eyes, right? Let's say I've asked you, okay, please revise, and I take a test, and every time you say, no sir, I could not revise because of some issue. 4 5 times later I'll say, no, I do not have trust in you. That is called eroding the image and credibility of judiciary. Great to hear that revisions are happening. Amazing. Okay, so now Shreya, Lok Adalat judgment cannot be challenged in any court. As I had given again the example yesterday, how can you challenge an award? That's not possible. So a decision given by Lok Adalat is not actually a decision. It is a compromise you have agreed. So you have gone to Lok Adalat and said, we are agreeing, please authorize it. That's it. So that can't be challenged, right? So that is it. Shiva, NJAC, no update. No update because government wants an executive to be there. Supreme Court says no. So as of now, it's in cold storage. No update at all. B. Rama, what is IPC? Indian Penal Code. If you commit any kind of crime, what shall be the punishment of the crime is mentioned under IPC. Finance Commission? Finance Commission. Why would we discuss Finance Commission right now? Is it Law Commission you are referring to? Because Finance Commission is a separate body under Article 280. The task of Finance Commission is to give recommendations on how much taxes can be devolved to state, how much to center, and how much taxes to each state. That's the task. And petition, request, it's an English word. When you petition, you file a request somewhere. Indian Evidence Act, Priyanka, if your subject optional is law, then maybe you'll have to study that. Otherwise, hey, it's not required. Yaram Sethi, what are the schemes related to courts, development, connect courts, each other, e-courts? Schemes related to courts. So far, not a single question on such topics has been asked, either in prelims or mains. We don't really see the need to go into depth into what is a current e-court system. Basically, as I gave an example yesterday of a concept of Nyay Mitra, which is of our concern, or say a concept of how the Supreme Court, the government, in order to ensure geo-tagging, has started a separate scheme of Vikas, Nyay Vikas. So these things which pertain to topics that we need to understand, sufficient. B. Rama, I think this is a task you should do on your own rather than me spoon feeding it. That would be more appropriate. Okay, Kunal, we'll discuss it right now. That is what is judicial activism, topic at hand. CRPC and IPC. CRPC basically is the procedure to be followed if a criminal activity has taken place. IPC is the punishment that has to be given if a criminal activity has taken place. Okay. Conditions for review petition. The only condition for review petition is that you have to satisfy the judge that some kind of grave injustice has occurred, or facts have not been presented carefully, or there may be a violation of principles of natural justice. That's the case for review petition. When you go to your teacher and ask them to reevaluate, what are the grounds that you go on? You feel that the marks have not been adequate. So if you are able to convince the judge that the justice has not been delivered properly, the judge may approve a review petition. That's it. Okay. Yes, Shweta, curative petition also the same time frame. Sir, in Rahul Gandhi defamation case, hopefully we'll discuss that Rahul Gandhi's disqualification today only, on the reasons of disqualification, on what ground has been disqualified. Now, can High Court follow right path? We don't know. But ideally, yes, the punishment is too harsh. 2 years is the maximum punishment. That should not have been given, right? So, to all the Rahul Gandhi fans, I believe it is very, very unlikely that the High Court will no, continue with the punishment of 2 years. We never give 2 years of jail sentence to anyone for defamation and all. That's too much. It's like giving the maximum possible punishment. That's not possible. Pressure groups and rights issues. Rights issues we'll deal under fundamental rights. Pressure groups is a topic to be covered under governance. Okay. So please focus on the topic I had mentioned in the polity syllabus, in the slides. So only those selected topics. Other topics are for governance also, social justice also. No, DB to PB is not a review petition. Review petition is after judgment is final and then you go and challenge it. And you cannot go and appeal in front of PB. The Supreme Court decides whether a matter is fit for priority bench or division bench. You only file a case. Supreme Court decides if the matter is fit for a division bench or a priority bench. You don't decide that. You can't go and say, sir, please send this matter to constitutional bench. No. Supreme Court decides. Once judgment is over, then if you ask for revaluation, that is called review petition. Okay. So, lot of questions. Extremely nice that revisions are happening in full swing. Good to know. No, shall local courts also have, what is this? Do not have record. What is this record? So local courts, the lower courts, they don't have the right to interpret the constitution and all. So please, it's only high courts and Supreme Court that can interpret the constitution. That is why court of records only high courts and Supreme Court. So before we begin, break timing for the day. So today is Sunday. So we are starting at 10. So let me write here only. Break timings for the break enthusiasts is going to be one break at 11:30 to 11:40. Second is the lunch break from 1 to 2. 1 to 2 is the lunch break. Then 3:30 to 3:40, we'll have a small tea break. Then 5 to 5:30, we'll have again a large half an hour tea break for full enjoyment and watching IPL also. And then around 6:50 to 7, we'll have one more break. And I'll finish the class today by 7:50 only, because at 8 I'll be starting the target prelims batch on the Byju's exam prep app. So around 7:50 will be done for the day. Okay, this is a break time. I hope it satisfies everyone. people who don't want too many breaks, plus people who want breaks. Now, let's come to what is going to be seemingly the most important topic. This topic will have a question in the main examination with almost a guarantee. You will be getting a question on judicial activism. It's a guarantee. It has been happening so far. It will continue to happen, some form or manner. So what exactly is activism? Firstly, forget judicial. What is activism? So the idea of activism is very simple. Let's say you go to a police station to file a complaint. Basically, we don't file complaints. We inform the police of some wrongdoing that has happened. And the police officer there refuses to entertain you, refuses to write your complaint. Then what do? You go to the SHO, the station house officer of that particular station. If he also is of no help, you go to the SP. If he is of no help, then you go to the IG of the division, DGP maybe, you go to High Court. If nobody is helping you, then what do? If every possible institutional setup has failed you, then what do? Gather your friends, sit on a dharna, protest, strike, forcing the government into taking their task seriously. Now, of course, dharnas, strikes, etc. are not the regular way of doing things, right? However, I was forced into doing it because there was no alternative. So when organs of the state, they fail to perform their tasks, somebody has to step in that domain and perform tasks for them, right? If judiciary does the same, we call it judicial activism. I'll explain it through an example or diagram. Now, think of this as a structure wherein we have various domains. So, this is the legislature, this is the executive, and this is the judiciary. Organs performing their tasks in their own domain. Domains are divided, right? And they perform their tasks, be it interpreting laws, implementing laws, or making laws. Now, let's say the judiciary or the legislature performs its tasks very nicely, but there are some areas where it though is responsible but does not perform the task properly, like in these areas. Not performing task, not performing task, not performing task. Same thing. Let's say we have the executive. They have some responsibilities, right? Remember, executive's responsibilities, very first class, we had discussed that. Executive's task is what? To make policies, programs, etc. Ram Javaya Kapoor case. I hope you remember that this is a task of the executive, right? Again here, executive was given this entire role to perform, but it is not performing certain tasks. Here is not performing tasks given to it properly. Now what is going to happen? Judiciary has its fixed role. This is the domain of judiciary, right? Where it has to perform its task. But because the executive has not performed its task properly, judiciary has to interfere. Judiciary has to interfere here, interfere here, interfere here, or interfere here, here, here. This is actually wrong. Why should judiciary enter the domain of executive or legislature? But it is forced into doing it because the executive and legislature are not performing their tasks properly, right? This is what is called activism. This that you see here, all these things, they are what are referred to judicial activism. Now, there can be a small problem. If legislature is performing its task, but judiciary says, no, you are performing your tasks, but please perform in the manner I am telling you to. When judiciary enters this area, now this is an area where the legislature is performing its task properly, or judiciary enters this area, now it is entering the domain where the executive and legislature were doing their task properly. But judiciary says, no, not like that. Do your tasks like I am telling you. Oh, you're making a law. No, make a law like I tell you to. That's not your task. See, if I did not perform, you have every right to interfere. But if I am performing, don't tell me how to do my tasks. That is called encroachment in the area where I'm already performing. This is a problem. This encroachment in that domain where they perform their tasks, these things are what we refer to normally as judicial overreach. Overreach, sometimes also called adventurism, sometimes also called populism, from the word popular. Judiciary wants to become popular, giving populist kind of judgments which will appeal to people at large, showcasing, oh, how nice the judiciary is, how amazing they are. So that's there. So this is what is judicial overreach and activism. The difference being, if the executive and legislature don't perform their tasks, then interference is called activism. If they are performing their task and then you interfere uselessly, that's called overreach. That's the difference. You can draw this diagram in your exam also, and that can fetch you very good marks. So there's nothing wrong. This is the most appropriate display in a diagrammatic form of judicial activism and overreach. And to think of it, I mean, why would we want judiciary to perform this task? So, see, I am very clear on this point. Every institution, every organ has been assigned a conventional role to perform, to play. And conventional means to achieve and fulfill those objectives. Anything beyond that amounts to activism. That is why we try to define it by saying that democracy's non-democratic alternative. When democratic institutions fail, meaning when your state has failed you, when the legislature has failed to perform, when the government is not doing its tasks properly, then judiciary is interfering. We know it is wrong. It is non-democratic. Why? Judiciary is not elected by people. It's an appointed authority. Yes or no? So if judiciary is trying to tell the government or the parliament how to do tasks properly, yes, we know it is non-democratic way of doing things. But the problem is our democratic institutions have failed. Somebody has to interfere. If judiciary does it, that's called judicial activism. And in fact, this particular idea comes from USA as well. In fact, just recently, during the pandemic, there's a very interesting observation that was made by the US Supreme Court. So US Supreme Court said that a public health emergency does not give the governors of US states and other public officials complete freedom to act on their own, to disregard the constitution just because there is a pandemic, there is a medical problem that persists. Very rightful. And that same concept is used in India also. In one small case, Justice D.Y. Chandrachud and Ravindra Bhatt, they made a statement jointly where they said that courts cannot be silent spectators when the constitutional rights of people are being infringed upon by government's policies. If the government is trying to interfere in people's personal space, government is trying to violate rights of people, government is trying to make laws which are unreasonable, government is trying to make policies which are completely arbitrary and random, the courts can't sit there silently and just look and enjoy. They have to interfere. So this is the reason, this is the very important element, the need for activism is this only, because that is what the courts say we want. We simply want constitutional justification for your actions. You want to make a policy? Does the constitution allow for it? If yes, no problem. Is your policy reasonable? Yes, no problem. Is your policy non-arbitrary? No problem. Is your policy protecting the right of citizens? No problem. If not, we'll have to interfere and cancel the policy. As simple as that. Because we are upholding the constitution. Sometimes you will not perform some tasks. For example, in the pandemic, we just saw the release of a movie called Bheed. I'm not really sure what the movie is all about. It seems it is targeting the migrant laborers and the crisis that they faced. Possibly, I'm not really sure. Anyway, so we have also seen Vishal Bhardwaj made a movie on this, and we have seen a documentary. We have seen the cases of people migrating back to their homes. Some of the famous journalists from some news channels would go and conduct interviews there. We saw the dreadful situation of people walking hundreds of miles, and largely the governments of the center and states failed to help them immediately. Of course, there's a crisis, they did not know how to react. At that point of time, the Supreme Court can definitely interfere and say, come on, provide them with essential supplies, provide them with essential services, and can give such orders. What's the harm in that? Somebody has to protect the rights of people because the government is sitting silently, taking no action. That is what is called judicial activism. I hope now this point is clear on what exactly is judicial activism. And to further help you understand, there are some genuine reasons as to why we have activism. See, reason number one, there is lot of asymmetry of power in the constitution. Constitution does not provide symmetry of power. I'll tell you why. Even though the Supreme Court itself says that executive is almighty, all powerful. Really? You are almighty, all powerful because you can interpret the constitution in any form or manner you want. Where is the equality of power? There is no equality of power. Do you think all the organs L, E, J are equal? They are not equal. What is legislature's value? Executive completely hijacks the legislature. The government controls majority in the legislature. Do you think, very simple example. All the bills passed in the country are made by whom? Government only. Not some random MP from Congress or other party. It's all the ministers in BJP. When Congress was in power, it was all the ministers of Congress. So what is the value of legislature? Right? So legislature is slightly lower in power compared to government. And then comes the Supreme Court. Because you can interpret the laws in any form and manner. And then you have Article 142 giving complete justice. So there is asymmetry, meaning non-equal powers. Non-equal powers for or between L, E, J. Then indifferent approach of other organs. As I said, the legislature, the executive sometimes don't perform their task properly. People are suffering, let them suffer. Let me make some money. People are suffering. let us firstly win the election, control power. So the indifferent approach towards people suffering in this country, the failure of organs to perform, right? So basically, it is nothing but the failure of L and E, legislature and executive, to perform their designated activities or tasks, is what is forcing the courts, and the courts must do it. I remember there was a very interesting statement made by Justice P.N. Bhagwati. Uh, so Justice P.N. Bhagwati made a statement where he said that in 1982, S.P. Gupta case, he said the court has to innovate, and I'm quoting almost verbatim, the court has to innovate new methods and strategies to provide access to justice to large masses of people who are denied basic human rights, to whom freedom and liberty has no meaning. So it's the court's responsibility, is what they say, that it's our duty, our responsibility to provide these people with basic necessities of life, access to justice. If the governments won't do it, we'll do it. That is the reason for activism. Then increasing awareness amongst masses. Now people are aware of their rights. They file petitions in courts. They say, sir, please instruct the government, give orders. That's there. Then globalization. Now, because of globalization, we know very well the advanced level of rights that are there, say in countries like Canada, or say the Nordic countries, Norway, Denmark, Iceland, Finland, Sweden, right? And we want the same kind of rights to be given to us also. So currently, the debate going on giving rights, equal rights for marriage to homosexuals, or upholding dignity of women with respect to marital rape. So these are concepts that have always come through the Supreme Court judgments of other countries, or sometimes laws in other countries. And these concepts in our country are seeping in through globalization only, right? Some NGO, some judge here, maybe some social activist reads those articles, reads those, goes to a country, sees those things happening, tries to emulate them, tries to ask the court, sir, please give orders to government. We want those rights. Did the Nalsa not win a judgment finally to ensure transgender rights? Finally, Supreme Court gave a judgment to ensure that no homosexual will be criminalized, right? So these things have seeped in because of globalization. We always draw inspiration from other countries. That's there. Then active media. Media has played a very important role because media has spread information far and wide on what is wrong, what is right. Some good policies in foreign countries, they are made known to us. Wrong things that we have been doing are made known to us. So that's a very important element. A very important reason why judiciary also gets information is because of active media. And lastly, advent of something called PIL. So just to discuss on this point, what exactly is PIL? PIL stands for public interest litigation, right? So here you have two different photographs of two vastly different lawyers, right? One is Surya in Jai Bhim, the other is Arshad Varsi in Jolly LLB. I'm sure most of you must have seen both the movies. And for those who have not, you should. Anyway, so what is this PIL as a concept? This concept of PIL has come up through Justice P.N. Bhagwati only. Justice P.N. Bhagwati was actually the former Chief Justice of India, and also V.R. Krishna Iyer. These two judges are largely attributed with initiating the concept of PIL. So that's there. Now, when it comes to PIL, what exactly does it entail? So I'll have to help you understand through a simple example. Let us say you are living in Madhya Pradesh, Gwalior, Bhopal, wherever, and you hear or read a news item that somebody's house in Assam, Guwahati, gets robbed, will you go and file a police complaint in Bhopal that Mr. ABC's house was robbed? The police will ask, do you know him? You say, no, I don't know. I have no idea who he is. He is some person I saw in newspaper. The police will say, get lost. What is this nonsense? This is called locus standi or locus standi. So there is something called concept of locus standi. This basically means only affected parties can file a case. But if you are not an affected party from that action, what's your concern? Mind your own business. Same thing. So this basically means only affected person, group can file case in court. But then that may not always be possible. Simple example. Let's say you are living in your house and say in a society, a flat maybe, and just besides your flat there's a flat where you constantly see the husband beating the wife or vice versa. Anything can happen today's day and age. Let's assume husband beating the wife. Now in that case, the wife should ideally go and complain of domestic violence. But if such activities take place, the wife may be too afraid to go and complain. Fear could be a reason. Or if the husband is getting beaten, shame could be a reason. So they are not going and complaining, maybe because of lack of knowledge, lack of funds. You know that you can go to Nalsa, Salsa, Dalsa. They don't know. It could be lack of awareness. It could be lack of courage. So not every time can somebody whose rights are violated approach the courts. It's not possible. Sometimes we have to also help others who don't have, say, the information, who don't have the knowledge, who don't have the courage to file a court case. So if we become very strict that are you impacted? Is the husband beating you? Get lost. Let the wife come. That cannot always be there. Let's say kids are being involved in some kind of child labor. The kids don't know law. They can't go to court and file a case. Somebody else has to. This concept of somebody else filing a case on somebody else's behalf to protect their rights, this kind of concept came into being in the late 1970s with the advent of, say, a very famous case called the Bombay Back Bay case. But then the most popular case, wherein we saw the courts accepting such petitions from random NGOs, social activists, third person, was the Husainara Khatun case. So this is the origin of what we call as PILs, public interest litigation, meaning what? The people are filing a case which largely impacts public. So it is more like a social action litigation. That is what is called PIL, public interest litigation. So in the concept of PIL, locus standi is diluted and the court allows even non-affected party to file a case on somebody else's behalf. This concept is diluted, non-affected person or a group can approach courts on behalf of others. For what? To uphold their rights or provide justice. This is called PIL. We are allowing you to file a case in public interest litigation. That is the beauty of this concept of PIL. Okay. Now, one more thing, as I said, the idea was pioneered by Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. These two people are said to be the ones who supported these litigations to a large extent. In fact, I believe this very famous judge, Justice R.S. Sodhi, who was a former Delhi High Court judge, he gave a statement once that PILs have been able to pick up the grievances of people as a whole with the objective of the improvement of the system as a whole. When, and very important, when individuals could not come to court, the courts became obliged to look into a situation as was prevalent and bring improvement in the system. Bring improvement in the system. Former Delhi High Court judge says this. So, of course, PILs have largely been helpful. And as I said, the very classic example of PIL is, the most famous PIL, which is also sometimes called the mother of all PILs, was the Husainara Khatun case of 1980, mother of all PILs. Now, let me clarify, this was not the first PIL, but this is the most popular PIL, so people feel this is the first PIL. And this is called the mother of all PILs. Basically, this PIL was filed with reference to roughly 40,000 people across the country lying in prisons as under trials for long periods of time. And then somebody approached the court saying, what the hell is this, sir? See, these people who are under trials, their crime has not been proved. They are in jail for such long periods of time. And then the court took cognizance, took notice of the matter, and issued order to release those people, right? If they were found fit or the crime was not heinous, etc. So this opened floodgates for more and more people to approach the courts, upholding rights of people on various accounts. So, some examples of popular PILs in front of you. For example, so many PILs have been filed on account of police reform. Like the court has passed orders to humanize prison administration. Prison administration has to be humanized, meaning what? Please behave decently with prisoners. They also have right to life, right? In fact, we believe the right to live with dignity is also with the living and the dead. Recently, there's a very interesting movie which released on Netflix. Purush Pretam, I believe, is what is the name of the movie. It's again Malayali movie. So you should watch that movie. It's an amazing movie on how a dead body has to be exhumed and then what is the procedure of exhumation of dead bodies and etc. So it's I think available on Sony Live, I believe. So that's how it is. Right to live with dignity is there even after you die. We respect the dead bodies as well. So why not prisoners? In fact, there have been a lot of British made laws which don't treat prisoners properly. For example, under the Prisons Act, there used to be a section which said that beating a prisoner with a ralton means a stick which is half inches in diameter is allowed. It was in 1979 that Supreme Court said, what kind of nonsense is this? You are beating prisoners. Though it's another matter that still goes on and people are silent. But that's the reality. Or under trials in jail for long periods of time. This was the Husainara Khatun case, which I was referring to. This case only. Husainara Khatun case, 1980. Or right to speedy trial, though it's largely remained on paper. because right to speedy trial depends on so many factors: availability of the infrastructure, the pending cases in the court, etc. But everybody has a right to get quick trial in the court, not delay the case too much. But we have seen situations wherein people have had to wait in jails. I'll give you a true example. There's a situation where somebody's date came finally, and the hearing came in the court. And when the judge started reading the hearing case, his date came after 12 years. He was in jail for 12 years. And the crime he had been accused of committing, the maximum punishment for that crime was just 2 years. But he could not get a court date only. Poor person sitting in jail for 12 years. And then the judge with folded hands apologized, saying, "I'm extremely sorry," and asked the court to grant a compensation of 25,000 rupees. Such huge amount for somebody's 12 years of life, right? This is also a reality. Somebody somewhere is suffering at every point of time, right? And nation building is not complete if they and their lives are not improved. As I've always said, it is your duty to ensure that the lives of these people is improved. Rich and elite will handle their business properly, don't worry. It's these people who need your support. So that is why the role of civil servant, the commitment role, committed towards the upliftment of poorest of poor, that's your responsibility in future. Then a humane treatment of detainees. Whenever you detain somebody, right, please treat them in a human fashion. Don't beat them. No third degree, no torture. This was actually given by court in DK Basu case. See how court has given various judgments to improve the lives of people even in jails. Limiting solitary confinement. Do you remember? Solitary confinement should not be allowed. Which judgment? Shatrughan Chauhan case. I hope you remember we had said this case under that topic clemency powers. Then avoiding excessive handcuffing. That's also not to be done. In fact, handcuffing is not allowed only. So in the movies, they'll always show when the police comes, they show handcuffs. That means arrest. But handcuffing is actually not allowed in the country. For handcuffing somebody, you have to take the permission of the magistrate. And if you have handcuffed somebody, you have to inform the magistrate the reasons for handcuffing somebody. Right? So this is there. Then Shatrughan Chauhan case, why will be 1914? After independence, the judgment has been passed. It will be 2014 only, right? Then women. So as far as women are concerned, lot of elements with respect to judgments. A very simple example is sexual harassment at workplace. I'll give you a very important judgment in this regard. So in 1997, a judgment was passed, and you would still remember, all those people who are working professionals, you would know there's a case called Vishakha Guidelines. Vishakha Guidelines. In fact, Vishakha Guidelines were a result of a very inhuman kind of case that happened in a country. So back in the 1990s, just a small anecdote, back in 1990s, there was this lady called Bhavri Devi, and she was government's employee. I mean, not an employee per se, but she was roped in by the government to spread information against the child marriages being rampant in Rajasthan, 1990s. So one day she informed the local district magistrate of some families gathering together at one place and performing some child marriages. She reported this, and this came into news to the district magistrate. The DM with all his officials went there, but at the last moment, those people who were planning the marriages, they changed the spot and they could not be caught. Anyway, But this became news in the village that, oh, this Bhavari Devi is acting over smart. A woman, and that too she belonged to a lower caste community. Oh, lower caste woman acting smart against us upper caste people. After a few days, her husband was being beaten in the fields by some upper caste men of the village. Bhavari Devi ran to protect him, and then she was allegedly raped by the 5 people there. Initially, the court did not even file a case. The local court did not even file a case. I mean, the court dismissed the case. Then some NGOs went to Rajasthan High Court and asked the Jodhpur High Court, sir, please ask the lower court to file a case. And then Jodhpur High Court instructed the lower court, come on, file a case. Case was filed. The matter went to trial, and the district court gave a judgment that no, rape has not been committed. Why? It gave various kind of reasons. One reason court gave was Bhavi Devi belonged to a lower caste community, and since all the men involved were from the upper castes, normally upper caste people don't even touch lower caste people, so such rapes cannot be committed only. Or one more argument was by the court was, reason was, in these 5 people, there's an uncle and a nephew. How can an uncle and nephew commit this crime in front of each other? So based on these grounds, the court acquitted all the accused. Anyway, coming to Vishaka guidelines, so what happened? But a lot of NGOs became very cautious. Let's see. Bhavari Devi was only performing her tasks that the government had asked her to do, that spread information against child marriage. If a woman is not safe in the confines of practicing her job properly, then where will she be safe? That is why people went to Supreme Court asking Supreme Court to give some guidelines. And Supreme Court gave what we know as the Vishaka guidelines, instructing every organization to maintain a proper code of ethics and conduct to prevent sexual harassment of women at workplace. And there was no law in the country for 16 years, mind you. It was only in 2013, after the Nirbhaya case, that the government made a law. That law is called the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. It replaced Vishaka guidelines. So Supreme Court's guidelines acted as a law in the country for 16 years. Of course, the sad part is that we always have to wait for some kind of horrendous accident to take place to make laws. Otherwise, better sense will not prevail in our politicians on their own. Secondly, coming to Bhavari Devi, what happened to her? Bhavari Devi is still waiting for justice actually. So the case is still there in the court because of lack of witness and evidences. The case is still pending in the court. That's it. I think her husband passed away a couple of years back, and that's a sad reality of the fast-paced justice delivery system in our country. Anyway, then we have had this nutritional and feeding norms. So for all the pregnant women or the lactating women, we also have to ensure the right kind of nutritional diet for them and the feeding norms for the babies. So this was actually given by the court in a case called PUCL case 2009. PUCL stands for it's an NGO called People's Union for Civil Liberties. You can Google for the full form. Then inheritance of property rights, that's also something which has been incorporated through judgments. Or regulating sale of acid. This was the landmark Lakshmi case of 2006. And I now hope you know this point, that nobody is allowed to purchase or sell acid without ID proof. So you cannot simply go to any shop and purchase acid. Why? Because some jilted one-sided lovers, they thought, if somebody is not responding to my love, let me destroy her face. And they threw acid on somebody's face. Just recently, Supreme Court has given compensation to the victims of acid attack. Recently, one Calcutta High Court asked the government to give 36 lakh compensation to an acid attack victim. Such things do happen. Then separate police lockups for women. That has also come through Supreme Court judgments, right? So all these things have come through Supreme Court judgments upholding rights of various categories of people, all through PILs. Then for child rights, establishment of juvenile courts with trained officers. So juvenile courts are courts wherein you have all these kids under 18 and their cases are discussed. So you should have trained officers who deal with kids. Sheila Barse case. Most of these people, names you hear, they are all social activists, NGOs, etc. Okay, so that's there. Nitesh, cleaning acid is not of that high concentration that can kill somebody or impart an injury of that kind. So we are talking about the factory grade acid, right? For that. Anyway, now apart from that, preventing child labor. Supreme Court has given so many judgments on preventing child labor. No child labor in circuses. That's come through a Supreme Court judgment, mind you. There's a case called Bachpan Bachao Andolan case of 2011. Bachpan Bachao. If you are not aware, there's a Nobel laureate, Kailash Satyarthi. He runs this NGO and has saved over lakhs of kids from child labor. Then no employing of children in match factories. Match factories, you cannot employ kids. Who gave this judgment? Supreme Court. MC Mehta, very famous social activist, filed a case. In 1996. Or kids will not be employed in carpet factories. So carpet making factories, non-employing kids. Again, Supreme Court judgment. Bandhua Mukti Morcha. So all these things have come through Supreme Court judgments only. Right? Or environment, upholding the environment, healthy environment, polluter pays principle. So all these elements that we are mentioning here, they have all been a part of what? They have all been a part of Supreme Court judgments, right? For example, healthy environment. Healthy environment is a part of Article 21, fundamental right to life. This was given in the Dehradun quarrying case of 1988. Or polluter pays principle. Again, a concept where if you have polluted, you have to compensate for the pollution. Absolute liability principle. You'll be reading all of these in your environment classes. More clarity on what these things mean. Or firecracker ban. So this concept of firecracker ban, though started on a very wrong note. Why I say wrong note is because the Supreme Court did not take proper steps to look into the correct aspect of banning firecrackers and all. They simply randomly issued some order and said firecracker ban should be there initially. But later on, the Supreme Court asked some people to conduct surveys, etc. And then post the conduct of surveys and some response, then Supreme Court actually issued orders for banning of firecrackers, etc. So that is there. And this concept of firecracker ban started in 2015, but a proper judgment came in 2017. There was this case called the Arjun Gupta case of 2017, where Supreme Court said firecracker ban because it causes a lot of pollution. Or all those people who are fans of cars, right? And who are planning to purchase some cars in future. You must have seen now Tata has released its new Safari and Harrier and Nexon Dark Red Edition with the BS6 second stage engine. What is Bharat Stage 6 norms or Bharat Stage 4 norms? What are these norms? These are basically based on the European norms of vehicular emission. So vehicles emit these gases. nitrogen oxides and sulfur oxide gases and various other particulate matters. So we have to refine our engines to reduce the emission of these gases. So less and less of vehicular emission. Again, you'll discuss this in your environment classes. So the government has been asking the automobile industry to improve their engines to reduce the vehicular emission, the pollutants. But when you modify your engine, it takes a lot of time, energy, and money. And finally, when the government was not showing interest in giving orders to the automobile sector, the Supreme Court interfered and said, okay, we are giving order. You have to implement Bharat Stage 4 norms. Or recently in the MC Mehta case, Bharat Stage 6 norms. It just happened in 2018 that Supreme Court said by 2020, Bharat Stage 6 norms, every vehicle should have stage 6 norms of vehicular emission, meaning you have to emit or the vehicle can only emit these gases to a certain limit, not more than that. That is called the Bharat Stage 6 norms. This is also through the same person, MC Mehta, who filed a case in 2018, right? So all these things, environmental cases. Then we have for governance matters. You'll be surprised that there have been so many important judgments to improve governance in the country. Very simple example. Now, if anybody wants to contest elections, what happens is every candidate has to, in their nomination paper, give details of all their criminal history. Antecedent means past. All the criminal cases filed against him or her, when he has been booked, when he has been punished, give details. How do you think this has happened? Do you think our politicians will make such laws to expose themselves? Of course not. Supreme Court judgment. It was the NGO called People's Union for Civil Liberties, PUCL, and the judgment in 2003, wherein the government scolded, the Supreme Court scolded the government and said, you are not taking any steps. From now onwards, any candidate who wants to contest elections, in their nomination paper, there has to be a column where they have to fill all their criminal past. Whatever cases are filed, any pending case is there, everything. That's how we come to know of our great history and criminal past of our politicians. All thanks to Supreme Court. Then appointing special investigating teams, SITs. So on various situations, we have seen that Supreme Court appoints SITs, special investigation teams, because it feels that the government is not serious about the case, or the government wants to appoint those officers to handle the case who are very pliable officers. So the Supreme Court says, if you're not appointing good officers, I will appoint good officers. Special investigation teams. Or this very interesting case of CBI director. CBI director, the appointment and tenure. So directors of CBI are appointed by a team or a committee of Prime Minister, leader of opposition in the Lok Sabha, and the CJI. Who do you think has said this? Supreme Court. There was a case called Vineet Narayan case of 1997. It was in this case that Supreme Court finally made this statement that the directors here have to be appointed only after the recommendation of the 3-member committee. And not just this, they also went ahead and said that when you're appointing a director, the minimum tenure to appoint a director has to be 2 years, right? Now it has been increased further, but Supreme Court had said it has to be at least 2 years. So how did the judgment come? It came, of course, through the Supreme Court judgment only. So all these things, or even as recently as the case was Election Commission, the election commissioners, their appointment also is being done through the same committee now. We'll discuss this shortly when you study Election Commission. All these are examples of Supreme Court giving judgment because some NGO, some social activists, people like you and me who are filing cases and getting the courts to uphold rights of people where the governments have failed, where the parliament has failed. All examples of, you may say, interference or activism, right? So this is what is activism. And this is a situation wherein we hope that Supreme Courts keep on interfering, and rightfully. But again, the whole point is that we really want that there should not be a need for interference. We want that the better sense should prevail in the government on their own so as to perform the tasks on their own. So this is all about the PILs, public interest litigations. Okay, so that's it. Now, coming to some recent examples. So why I'm giving all these examples is they ask these questions in the examinations, and you should quote these examples, mug up these examples as many as you can, because that is what they ask in the examination, and you have to quote these examples. So recently you will find that in the case of one more important thing. So we have had this discussion a lot. I'm sure a lot of you here are fans of the pets, dogs, cats also. I'm not sure being fans of cats is a dangerous thing. But anyway, fans of cats, dogs, and stray dogs. A lot of people love to feed the stray dogs also. So, and we have also seen rise of some incidents of stray dogs biting kids, killing them, right? So, how do we keep a check on that? So, in Kerala, the Kerala High Court actually ordered the government, saying that it is the state's responsibility to protect citizens from ferocious dogs. It's important. And that is why just recently the various state governments and central governments are making rules, passing rules on how to feed the stray dogs. Rules are being made now by the governments that there should be a designated area, only there you can feed the stray dogs, etc. Why? Because Kerala High Court made a judgment. Or if you remember, I just giving the example, various high courts are passing judgments with respect to uh, directing the governments to pay compensation for acid attack victims. That's there. Then, when it came to Delhi High Court, it gave a judgment recently. It asked the government that why don't you go for crowdfunding, asking people to pool in some funds, and those funds can be used to treat rare diseases. Or Supreme Court. So in Telangana, a couple of years, just I think last year only, Telangana government, in order to purify the ration card system, because it said that a lot of people who are undeserving, they have received ration cards. It cancelled 19 lakh ration cards on its own without any on-field verification. Supreme Court cancelled the order, said you firstly go and conduct an on-field verification at the ground and then cancel the ration cards. Don't cancel it randomly. Or very important, you must be aware of the bird called the Great Indian Bustard. Bustard, spelling is very important. Okay, so Great Indian Bustard. Now what happens is these birds are very heavy. They don't fly uh, at a very high height. So, and these birds are largely found in Gujarat and Rajasthan. So there, the government is also planning a lot of solar power, etc., and they have a lot of transmission lines which transport the electricity from one place to another. Now, these birds, when they fly, they constantly collide with these transmission wires, the electric wires, and they die. So, state was silent. You can't remove transmission lines and all. It's required electricity after all. It was only after the Rajasthan Supreme Court ordered the government of Rajasthan and Gujarat that you have to install something called bird diverter. It's a plastic object you install on the transmission line. The birds can see the line, the object from far off place and can change their course. Otherwise, in deserts and all those areas, lines cannot be seen by birds. And once they come too close, they cannot change their course very quickly and hence collide and die. So that is also there. The Great Indian Bustard, lesser floricans, their deaths were happening due to collision. Supreme Court judgment has come, which has helped the birds also. So all these have come through what? Supreme Court and High Court judgments. So always understand, remember these judgments. You can quote them at least for the next 2, 3, 4 years, no problem. After 4 years, you can revamp these and see some new examples. So don't go on a research. Every day something is happening. Just remember 4, 5 examples, that will be sufficient. Don't go crazy and overboard. Okay, that's it. So what are the positive implications of activism? Advantages, benefits. See, first things first, activism's number one benefit is that it prevents undue administrative discretion. Now the government cannot randomly take decisions to appease vote bank. Simple example. Governments know very well that reservation is a very important matter. Jobs, after all, government jobs, security of tenure. So they keep on classifying various categories into OBCs because that's a very vague kind of criteria. For SC/ST, it's a very specific criteria, right? You cannot randomly classify everyone as a uh, uh, as a scheduled caste or scheduled tribe. So that's there. However, for OBC, it's slightly more vague as a criteria. A lot depends on government and government data. So we have found cases where OBC tag has been given to Jats or even Marathas. And on both the occasions, Supreme Court has cancelled such reservations which are not based on facts, right? Whether it was a Ram Singh case or the Maratha judgment case. Then it has also promoted transparency in governance. As I said, the example of PUCL 2003, where every candidate has to publish the criminal antecedents, the criminal past, or a very famous judgment was also there, Abhiram Singh judgment in 2017. You know, in this particular case, Supreme Court said that all these parties which are giving tickets to people with a criminal background, they have to publish the criminal history of the person in daily newspaper. So now you have to declare the criminal past of a person in a daily newspaper. Publish criminal past of candidates. Then sometimes, governments can shift their responsibilities on the courts also. See, governments don't like to take tough decisions which can violate their voter base. I'll give a very good example. If you have seen this movie called Nayak, that Shankar's movie, One Day Chief Minister. So Anil Kapoor or Arjun was the actor in the original version in Tamil. So if you remember, the initial part of the movie, there was a scene where Anil Kapoor, there's this student who wants to get into the bus and he's thrown off. He, I think, dies, and then there's an entire chaos and all. Buses are being burned, strike all over, and Anil Kapoor comes and records everything. So in that situation, Anil Kapoor records a small discussion where, if you remember, the police commissioner calls the chief minister and tells, "Sir, people are fighting, people are killing themselves. What should we do?" The CM says, "Don't do anything. The students, they form voter base for my party. The bus conductor, he belongs to my same caste. Don't take any step." Right? Don't take any step. Let them fight, let them cry, let them go home. That's what governments do sometimes. They know very well that if I pass any difficult order, if I make a difficult law, that sector will suffer. Governance can suffer. Maybe vote bank can suffer. Sometimes they don't take difficult decisions. I'll give a very simple example. Government and parliaments. The issue of Sabrimala case. What happened there? I mean, see, we'll discuss this point later on of Supreme Court judgment. But allowing women entry into a place of worship, it is the prerogative of the government or parliament. Supreme Court has no interest in that. Who are you to decide? But governments knew very well, if I pass a judgment, allow entry, all the people who are believers in Sabrimala and Lord Ayappa will get very angry. If I say don't allow entry, then all the liberal feminists will be very angry. So what do? Keep quiet. Let the court decide. So they also shift their burden on the courts. That Bharat stage 3 to 4 movement, if the government made some regulation, then the automobile sector would suffer. And a lot of these big business houses fund the government, fund the political parties into winning elections. So why should I make strict orders? Let the court make an order. And once court gives an order, I'll say, see, what can I do? You have to improve your engine because court has said it. I have no interest. Court is telling, please implement. What to do? So these are the cases. Example, BS3 to 4 or 4 to 6. Even things like Sabrimala. Then one more thing, as I said, if you look at, we have not seen the rights. Nitesh, there is no debate right on Sabrimala. Understand the context. We'll discuss Sabrimala later on. Don't worry. Understand the context of the example, please. We'll discuss Sabrimala in detail when we study fundamental rights. Don't worry. When it comes to positive implications, one more thing. If you look at fundamental rights, say Article 21, very basic, right? It says, no one shall be deprived of their life or liberty, save as in procedure established by law. Which means what? You have a right to life and liberty. That's it. Is that it? I mean, life and liberty means what? Just living, breathing somehow. Or right to reputation, right to dignity, right against handcuffing, right against public hanging, right to privacy, right to a noise-free environment, right to a pollution-free environment. So how have we expanded the scope of rights? Do you think governments have done it? No. Supreme Court judgments. Everything you see where now the right has been expanded. Simple example. There is something called freedom of speech and expression. Nowhere in the fundamental rights in our country is it mentioned there will be freedom of press. Still we have freedom of press. How? Supreme Court, Ramesh Thapar case, 1950, freedom of press. Right to access information over the internet, Anuradha Bhasin case. Supreme Court constantly has been expanding the scope of rights. Why? Because we have to always understand, we have to improve ourselves, right? We have to reconcile the permanent values with the transitory changes, the socio-cultural changes in a country which keep on happening. We have to reconcile them, striking the balance. And the best example here is expanding scope of fundamental rights. Then it has also helped in checking government inaction, sometimes in the areas of environment, police reforms, corruption, electoral reforms. Governments don't want to take any step. So if you don't take any step, Supreme Court gives judgments. We have seen so many cases of environment, governance reforms, etc., where Supreme Court has taken steps, giving judgments on various matters. And it has also sometimes played a complementary role with respect to Parliament. A very good example is the Vishakha guidelines. I mean, Vishakha guidelines were the only guidelines available to prevent sexual harassment of women at workplace. Only guidelines available for 16 years. Or even something as basic as decriminalizing homosexuality. That is section 377 under IPC. It was read down by Supreme Court. So this was done. This should have been done ideally by the Parliament, but Supreme Court did it. It gave the Parliament ample opportunity for 4 years, waited. The parliament took no step. In the Navtej Singh Johar case, Supreme Court said, we'll have to remove this law. This is wrong. Why should the government punish anyone just because of their sexual preference? Let it be. It's a personal choice. What you do inside the closed doors of a room, nobody has any interest in knowing it, and nobody has any interest in punishing you also. It's your personal choice. That's it. Vipin first point simply says that, see, governments cannot take random or arbitrary decisions. If government randomly said Maratha reservation, Supreme Court said, where is the data? Where is the fact? Show me facts. So you cannot simply take any random decision and say it's a policy matter. Don't interfere. No. Every policy. I opened my explanation with this statement only, that Supreme Court said that constitutional justification can be sought for every policy, every program, every step that you take. Is it constitutionally valid? Is it reasonable? Is it non-arbitrary? Is it upholding rights of people? If yes, no problem. Else, we'll interfere. That is what is preventing the undue discretion of government in administrative decisions. Okay, so Vipin, that reservation has only come after the government was forced by Supreme Court into providing data based on which the reservation was to be provided. Understand this point. It only came after Supreme Court asked the government, please give data. It cannot be done randomly. Secondly, for Marathas also, you may say there was a Gaikwad committee report which gave recommendations, but the Supreme Court did not accept the Gaikwad committee report. So that's there. Okay, so these are all advantages. Can PIL cases be filed using free legal service? Free legal service. What is free legal service? That NALSA. See, PILs cannot be filed using NALSA because it is meant for people largely who are from the weaker sections to get their rights upheld. That may not be possible. NALSA as an organization can file a case, but you cannot use NALSA to file a case like this. NALSA may provide you with legal help, but may not give you economic help in that case. What is the fourth point? It has help. I think this is the most important point, which is the most self-explanatory point. That, see, we will never be liberal enough. What was wrong or what is right now was, or what is wrong now was right 50 years back. People used to smoke in planes, closed areas, women, pregnant women, small kids, asthma patients, old men sitting there, and you are allowed to smoke. It's unthinkable now. It is allowed back then. So now it's not allowed, right? Bullying, teasing, such things were common. It's not allowed now. What is okay right now may not be okay tomorrow. But how do we change all these things? Somebody has to look into these elements and incorporate these changing socio-cultural circumstances of the country. Supreme Court does it, striking the balance. There is something called a constitutional value, and there's also the changing times. That is why, say 50, 60 years back, forget live-in relationships. Intercaste marriages were dreaded and live-in was unthinkable. But now it's okay. And the courts have also said equal protection, equal rights, almost at par with married couple, because they know that the current reality is that people in large cities and all are in a live-in relationship. We have to adopt to the changing lifestyle. We have to also adapt with the changing circumstances. So that's how the judgments come, and they try to strike the balance. These are all nice things, good things. Okay. But what are the challenges? But before I discuss the issues, let me also ask you something. I mean, what do you exactly mean by activism. I mean, if the government has failed to perform their tasks, okay. If the government or the parliament does not make a law on a very important topic, okay. But sometimes you'll find that the Supreme Court or the High Courts, they unnecessarily interfere in the functioning of the governments. Now that's where the limit is crossed. The moment you cross that limit, that is what is called overreach. So the issues of activism are not issues of activism per se. They are basically what we refer to as overreach or adventurism or even populism, just to win the hearts. I want to give nice judgments. Let's take a quick break, 10 minutes. We'll be back at 11:40 and we'll take up for discussion the matters of those situations where Supreme Court has crossed that limit and has interfered with the genuine functioning of the executive and the legislature. Okay, break please. Be back at 11:40. Okay, let's continue. So, long break, 3 extra minutes, full enjoyment time. Now, what doubts do we have? Shiva, no, that's not allowed. District courts cannot discard such laws. Nikhil, High Court jurisdiction is in state only. No, jurisdiction basically means the area of influence, and if it's for a particular state or group of states, it extends to that particular area only. Please display next slide, Shiva. I don't know what the context was, but anyway. All resolved. Okay. What do we have here? Abhijit, sir, judiciary interferes on its own or someone files case or PILs, then only. Both the things will happen. You can file a PIL, or Supreme Court can interfere on its own. That's what they call suo moto. We have taken suo moto cognizance of the matter, meaning on its own. That's also allowed. Shalu, if one does not follow judgment of Supreme Court, then what is the punishment? Decision by whom? If you don't follow Supreme Court judgment, then a punishment is decided by Supreme Court only or the High Courts only, depending on which court order you have disobeyed. And the punishment can range from fine to jail sentence of up to 6 months. Okay. Now, coming to issues. There are a lot of concerns also. Sometimes you will find that the Supreme Court has crossed the boundary, overreach has happened. To give you a simple example, liquor ban on national highways. NH stands for national highways. So back in 2016, in the K. Balu case versus Tamil Nadu, Supreme Court said, liquor should be banned within the vicinity of 500 meters from national highways, meaning within the range of 500 meters of national highways, no sale of liquor, no wine shop should be there. Why? What's the logic? There is no logic. Supreme Court's logic is based on just one thing. And what is that? That people get involved in road accidents and drunken driving cases. But just to clarify, data from NCRB, when it comes to such a situation where we are dealing with hardcore data, you have to be very, very sure on the value and quality of your data. So, in this situation where Supreme Court was so eager to ban liquor, let me clarify that data does not support the Supreme Court. See, I'm not saying let's not ban liquor, drink liquor and drive. No. But the whole point is the number of deaths that actually happened where a very, very small percentage of what actually was the total number of deaths. For example, this idea that we have to ban liquor is based on deaths. NCRB data says, government data says, in 2020, that is the latest data we have, in 2020, 1.33 lakh people died. Okay. Less than 4% people died because of drunken driving. In fact, most cases of deaths, accidents, and death was because of overspeeding and not drunken driving. So basically, you have this wrong notion without any understanding, without any study being conducted. You are given a decision and you are forcing it on people. That's not right. Or see, things like just a couple of years back. So during the COVID, we had elections in Tamil Nadu, etc. And during elections, of course, it is difficult to manage the crowd, especially on the polling booths. Now, one candidate from Karur constituency in Tamil Nadu M. Vijay Bhaskar, he filed a case asking the Supreme Court to give directions to Election Commission. And the Madras High Court in this particular case, in its court, gave an opinion. Madras High Court was very angry with the Election Commission that Election Commission has not been able to manage the booths properly and people have not maintained the social distancing norms properly inside and outside the booth. In fact, Madras High Court made a statement. Election Commission officials should be booked for murder charges because they have indirectly murdered so many people through the COVID. What kind of statement is this? And then Election Commission had to respond. What? Election Commission said, sir, it is not our responsibility. Outside the polling booth, it is a task of the State Disaster Management Authority, SDMA. They have to maintain the social distancing norms. Don't scold us uselessly. And now SDMA started responding, no. If elections are going on, ECI is responsibility. Now SDMA and ECI, they are fighting publicly. And Madras High Court judges are sitting back and enjoying, watching the fight. You are uselessly creating conflict between various institutions. And such kind of exasperations in your statements don't reflect nicely. Just think of this example I gave recently, yesterday also, this Nupur Sharma case, where J.B. Padiwal and Suryakant, I think two judge bench was there, and Justice Suryakant made a remark. He said, oh, you have come to get the cases transferred. People are being killed here and there. Because of your loose tongue, the country is on fire. Really? You are now blaming this woman only? If somebody is being beheaded somewhere, is the woman at fault? Is this how you deliver justice? And if you are so sure of the statement, why don't you make the statement a part of your judgment? So open court remarks should not be given so loosely because people outside read into those remarks. You have to be very cautious on what you say. You are not some random person sitting in your confines of your house and passing some statements. You are a judge, right? So people respect what you say. So there should be dignity in what you say. Then we have seen situations where Supreme Court actually originally banned firecrackers during Diwali without conducting any kind of survey. Frankly, that was not justified because pollution levels don't just rise because of Diwali. So the Supreme Court was very quiet when people were bursting crackers on the 1st of January or 31st December, but suddenly they were going crazy when people were bursting crackers during Diwali. You can see how the courts interfere constantly in the processions being taken out, right? So those things are not justified. In fact, the Sabrimala judgment was also not justified. Supreme Court has no knowledge, no expertise to pass such judgments like this. Whether to allow entry or not, it is the prerogative of the temple authorities and the governments. Who are you to pass such a judgment? Do you have knowledge of religion? Of course not. So sometimes they cross that boundary. Or the collegium system. What is that? That is overreach only. You have completely hijacked the system of appointment. Now think of this. Supreme Court has gone to an extent to interfere in the BCCI. So we know BCCI, right? Board of Cricket Corruption in India. Sorry, Board of Control for Cricket in India. So BCCI as a body is a private body. If there's any corruption there, it is not a corruption, it's a fraud. Understand, language is important. Corruption has been defined properly. Transparency International says that corruption, what is corruption? Public abuse for private gain. If any public office has been misused for personal gain, that is called corruption. BCCI is not a public body. It's a private Tamil Nadu-based cooperative society. Yes, it is controlling cricket to a large extent in the country, but that is called fraud. And then you have set up Lodha committee, etc., into probing into various things, appointing Vinod Rai. You may be a fan of cricket. Let the government decide on what action to be taken. So these kind of things don't behoove of the Supreme Court. And then there are various cases, where Supreme Court is silent on things happening in the country. complete inaction. I'll give you examples. What has been the response of Supreme Court on CAA protest? Or CAA, the law, as well as the Shaheen Bagh protests. Supreme Court has been silent. No steps being taken. Nothing. Farmer protests, you were silent. What else? Even in this case of Article 370's abrogation, you are silent. Whether that is correct or not, at least say something. It's been 4 years now. Or the EWS reservation. Now judgment has come last year. But we had to wait for 3-4 years for judgments to come. Then the very infamous case of Stan Swami's death. So I hope you remember the Bhima Koregaon matter. There was this case of Bhima Koregaon. Basically, Bhima Koregaon is a place, and there was this Battle of Koregaon. In your history class, you will be studying this very small topic, Battle of Koregaon, which was a part of the Third Anglo-Maratha War. So basically, the battle was between the Britishers, and the British army was largely comprised of Dalits, and it was against Peshwa Bajirao II, in which the British army won. So Dalits view this as their victory over a very decisive force, the Peshwas. So they celebrated this Koregaon victory, and especially after 1927. So in 1927, Dr. Ambedkar had gone to that site, and there's a victory pillar there. So every year, thousands and thousands of Dalits come there and celebrate. So on the 1st of January 2018 also, the Dalits in Pune, they went and celebrated this, they assembled there, over 1 lakh people. Then the local Marathas felt very bad about it. Some fight and scuffle broke, etc. And cases were registered. Some cases were now registered against some people of the Elgar Parishad, that Shaniwar Wada event. People like Stan Swami, Surendra Gadling, Sudha Bhardwaj, Kabir Kala Manch members, all these people, case was registered against them, that you are promoting Maoist activity and all, of which one was Stan Swami also. See, as far as these people are concerned, there is very little doubt that they are not spreading Maoist activity. Of course, there is proper allegation against these people that they normally spread this kind of agenda, propaganda against the Indian government and India in general. That's there, definitely. But that is not the point. The point is whether your views align with mine or not. I will still uphold your rights, right? So whether you are left winger, right winger, does not matter. I will always stand for upholding your fundamental rights. Stan Swami was in jail, over 80 years of age, old, and he was largely not mobile also, right? Ill, and the courts took no interest in granting him bail also. He finally died in the jail, I think in July 2021, died in the jail. Is this how we treat dissenters in our country? They may have their agenda, so what? We will have to stand up for your rights. Maybe the left-wing liberals will never stand up for a nationalist right, but we will always stand up for your rights. Don't worry. And this is the problem. Supreme Court is always silent. Mute spectator. Take no action. I mean, Siddiqui Kapan, he remained chained like an animal in jail for 6 months, Mathura jail. And you took no step. But if Kangana Ranaut goes to you, you take the case immediately. Arnab Goswami goes to you, you jump and take the case immediately. Afzal Guru's matter, you open the court at night. But for other people in this country, wait for justice. Is this justice? And then you pass remarks. Recently, one KM Joseph, when a petition was filed again with respect to the massacre of Brahmins in certain places and cases, he smirked and laughed at this matter. What is this matter? Brahmins getting massacred. You laugh at people's death. Is this your sensitivity towards a group? So this does not behoove of your post that you are holding. Where is the neutrality? There is no neutrality. This becomes a problem. So the behavior of Supreme Court has not been very even. So we can't really trust them. They may interfere, they may not interfere. If it's some rich elite person, they may interfere. If it's a common man, come on, get in line. What's so special? So that's also causing a problem. Anyway, so coming to these issues, issue number one, of course, it violates separation of power. Of course, that's the very blatant point here, that it violates separation of power. Sometimes I'll tell you, Supreme Court becomes very selective. So recently a case was filed. Ashwini Kumar Upadhyay filed a case in 2021, and the judgment came just recently, I think in the month of February, where a 3-judge bench dismissed the case and said Parliament should decide. So basically, Ashwini Kumar Upadhyay had filed a case telling that all these religious personal laws, they have different age for marriage. So some religions also allow for marriage of girls under 18. That's a minor, right? And in our country, minors don't have any kind of right to give any kind of guarantee. Minors cannot actually give consent, right? And then you're allowing child marriages to take place. So Ashwini Kumar Upadhyay said we should have uniform marriage age for every community. You can pass the judgment. It's very simple. But the court said, no, no, no. That's not our concern. Parliament will decide. What for Sabrimala you decided? That was not your concern. That was Parliament's concern. So we don't know what is your concern and what is not your concern. This kind of appeasement politics that is going on, that's causing a problem. Uniformity in your behavior is what we want. Whether it's a Hindu, Muslim, Christian, upper caste, lower caste, does not matter. There has to be equality in your approach. That is what is missing. Selective interference is the problem. So, violation of separation of powers, of course, that is there. Judiciary is interfering into the legislature and executive's domain. Number one. Number two, if you interfere too much into somebody's performance, then the person may also get fed up and say, I won't do any task only. Because if you interfere too much, what happens? It only causes delay in the decision making. For example, if you remember in your school days, college days, when you used to write your answers, and suddenly the invigilator came besides you and started looking into your notebook of what you're writing, you would stop writing because you'd feel uncomfortable. So you please go. You would not say, but you would feel, by please go, I want to write the answer. Same thing here. If you perform too much of scrutiny in everything, government, why are you doing this? Why this policy? Why that policy? Don't question so much. Also have faith in their understanding of the nuances. Be reasonable in your approach. So that is there. Now, because of that, only excessive interference causes unnecessary delays. Because as a government official, I'll feel whatever I do, the court will find some fault in me. Let's not do anything. Let it be. No, you only do, sir. Why will I do? My lords, you please pass a judgment. That is what pushes the governments into and the officers into becoming more and more lethargic. Why? Because excessive scrutiny is there. Number three, whenever any project is launched, if people protest, the very first step the Supreme Court takes, stay order, project, stop the project. Whether it is causing a loss of GDP to the country, whether it is causing loss of jobs for people, I don't care, stop the project. It's like some boss who enters here and says, stop, the big boss has come now, I will decide. So a lot of government projects get stalled in certain cases because of our great Supreme Court judgments. And also, tell me something. There's a very big issue. You have to understand that whenever you are dealing with such issues where public policy is involved, say setting up a factory. I'll give you a simple example. You have to set up an industry or a factory. It's a highly polycentric matter because lot of people are involved here. You have, say, the government of India, government of state. You have the MNC, which is starting the factory, the corporate. You have the people for employment. You have the people of the locals of the area, right? You have the NGOs, etc. So many stakeholders are there that courts should ideally not be the best place for such decisions because we want deliberations, discussions. Courts don't hold discussions, they give orders. Court is an adversarial system, A versus B. It is not meant for peaceful dispute settlement. Courts are meant to give a judgment where A wins, B loses. But here, we have to find a win-win situation. That will seldom take place in the court. Courts are not formed like this only. So, when you want to find a win-win situation for all parties, then courts may not be the right place. That is why polycentric issues need deliberations which cannot be secured in courts. Not possible only. Then it has led to inter-institutional conflict. I gave the example of Madras High Court passing a judgment, and then ECI started fighting with the State Disaster Management Authority. Then possibility of personal bias creeping in. That's always going to be the case. Because any policy or program made by the government is what? Any policy or program made by government is done after discussions amongst the ministers, amongst the people there, the parliament MPs there. But judges' decisions are based solely on personal bias and limited knowledge. So you'll always have personal bias creeping in when you are giving such a judgment. You will feel, I am only right. Government, politicians, fools, I am right. That's a problem. Then, problem of knowledge deficit. So, for example, if you take any kind of technical aspect, let's say there is some kind of issue going on where we have to deal with, say, there is a fight going on, intellectual property fight between, say, Qualcomm and some other company, and there is a Snapdragon processor discussions going on that topic. Supreme Court judge, what does he know of Snapdragon? He'll say, which dragon? Chinese dragon or Japanese dragon? So that is a problem. You may not have knowledge on every topic. You are expert in laws, knowledge of all the laws, but these technical matters, you are not really an expert. So it would be better if you refrain from giving such kind of statements. Then, so technical matters or very important, religious matters. We have seen Supreme Court interfering in religious matters and giving judgments. Milords, are you theologians? Have you read the religious books properly? In fact, most milords don't follow a religion also. In fact, our CGI is very clear. So just to please the people, you say, oh, ethos of the country, but your statements don't reflect the ethos of the country. So as a non-religious person who is an atheist or agnostic, what respect do you have for religion? Nothing. So again, this should come from parliament. So sometimes when you don't have knowledge of certain issues, I'll discuss this point later on also when you study Article 26. So you should refrain from interfering too much. And lastly, abuse of PILs, public interest litigations. So in our country, people love to file cases because PILs are not just seen as PILs. Lot of lawyers randomly keep on filing cases because once you file a case, then the case becomes popular. Your legal career is initiated. That is why we say PIL means please initiate my legal career. Paisa income litigation. That's what PIL stands for actually. And it is now that Supreme Court has become serious about it. There are situations where people file PILs for useless cases. Example, there was this NGO called Suraj India Trust. This NGO filed a whopping 64 PILs. 64 PILs in 5 years. Every month they would file a PIL only. Every month. Every month. And all PILs used to be rejected. Useless. No basis, nothing. Finally, Supreme Court said, please, enough is enough. Stop coming. And Supreme Court imposed a penalty of 25 lakh rupees. Finally, Supreme Court imposed 25 lakh penalty. Penalty imposed. Or this case of Shrikant Malushthe. So one Shrikant Malushthe, he went to court saying, sir, there is a problem. What's the problem? My lords, if you read the national anthem, Punjab, Sindh, Gujarat, Maratha. Punjab, Sindh, Gujarat, Maratha. So Sindh was there as a word, which is now Sindhu. So Punjab, Sindhu. So Sindh was the original word in the 1919 text. So Punjab, Sindh, Gujarat, Maratha. Punjab, India. Gujarat, India. Maratha, India. Sindh is in Pakistan. Our national anthem is violating the sovereignty of Pakistan. Court also got confused. What the hell is this? They called Home Ministry. Come on, respond. Then Sindhi community also responded. And then the government collectively said with Sindhi community that Sindh or Punjab or Gujarat or Maratha, it does not specify a geographical area only. It also specifies the culture, the ethos of that area. So the case was dismissed and the person warned adequately. So these things also keep on happening, right? Randomly will file PILs against Dhoni, against Rahul Gandhi, against Narendra Modi. Then recently I've seen PILs rename this place, rename the countries, rename the country only, rename this state, rename that state. Please, just because you have been given the opportunity to file a PIL, don't waste the court's time. That is what causes a problem. Complete disrespect for this very innovative method called PIL. That is why you also have to agree that public interest litigations, they were never meant to be a weapon to challenge the financial or economic decisions which are taken by the government in the exercise of its administrative power. You have to understand it. It is not some kind of weapon to harass the government, right? And also, rightfully, PIL is not the panacea for all the wrongs. It's not that Dolo 650, the Combiflam, that you eat it for anything. Fever, Dolo 650. Cancer, Dolo 650. Of course not. So PILs cannot be seen as that drug, the panacea, to correct every kind of wrong. There have been in recent times, increasing instances of abuse of PILs. That is why courts also have to re-emphasize the parameters within which PILs can be resorted to by the petitioners. And courts have to also re-emphasize on what ground should the PILs be entertained. It cannot simply be random. And again, I would like to quote Justice R.S. Sodhi only, who said at one point of time, there are always two sides to a coin. There will be people who will try to and exploit PILs. Now, whether courts allow themselves to be misused or not, that's where the wisdom of the court lies, right? So you have to decide. Anyway, so that's all as far as these issues are concerned. Polycentric basically refers to issues which have a very complicated interconnected relationship. Polycentric, multiple stakeholders are involved. That's called polycentric. It could have an economic ramification, it could have a cultural ramification, it could have a social ramification, it could have an environmental ramification. As I said, the factory example, polycentric. Government wants revenue, MNC wants profit, people want jobs, locals want their land, NGOs want a safe environment. So many elements are there, right? How can the courts delve into all these elements at the same time? Very difficult. These things can only come through discussions, deliberations. That's what is called polycentric issues. Priyanka, some PILs are also filed for changing, of course, yes, changing name of the country also. That's also there. So this is all about judicial activism. See, in short, I would like to conclude this entire argument by simply, this concluding remark will have to be judicial restraint. You have to understand when to interfere, when not to interfere. As I said, I just quoted Justice R.S. Sodhi's remark, and it is very rightful because, we have to also understand that the courts themselves have to decide whether you will be the organ to subvert democracy or you want to be an organ to uphold the rights of people. That is why we say the court should always stick to decision making process review only. Don't review the decision. What kind of policies, what kind of programs are to be made for the betterment of this country? Let the government and the parliament decide. It's not your prerogative. That's why no judicial governance. Very important. There cannot be judiciary governing the country because judiciary is not the place which has either this. How do we say? It's not the place which either has the power of purse or of sword. Purse meaning the parliament, allowing the spending of money. Sword meaning the executive, the power of government. So judiciary is not an appointed authority, right? So that is it. That is why you have to also understand there is complete lack of oversight. You are not accountable to people. Oversight in the sense funds, functions, functionaries, framework. Our judiciary cannot look into all these elements. You simply give a judgment and move on to the next case. But every judgment has a lot of ramifications which the governments have to take care of. That is why I said no judicial governance. We have to exercise judicial restraint. And also, one more thing, never make random off the cuff kind of remarks in the open courts because every remark you make is highly susceptible to misinterpretation. So, no judicial governance, exercise restraint. Restraint has to be exercised. All I'm saying is, if governments do something wrong, please interfere, but know when to stop. Because the strength of judiciary, mind you, lies in understanding its own limitations. And let me also close the argument by the statement that whenever you have misdirected enthusiasm, excessive enthusiasm, it is rarely consistent with impartiality. It will always be partial. So you have to understand and incorporate the element of restraint and interfere only when required. No negative remarks. Refrain from being overcritical of the government or the parliament. They also have tasks to perform. They also have a sense of respect and dignity. So don't, because you don't like people passing comments on you. Do the same. And we have seen judiciary loves to pass comments. They randomly call the CBI caged parrot. They have called the NHRC as paper tiger. They have called Lokpal as toothless tiger. It's like, no, that bully who harasses everybody, passing comments on everyone. Tomorrow we'll call the CAG glorified Munshi. But if we make a comment on you, you feel very angry and bad. Oh, criticizing judiciary. So a restraint has to be. That's all as far as judiciary is concerned. We are done with the judiciary. We'll now look into the tribunals. Before that, a small question. So look at this question, came in 2020. Judicial legislation. Judicial legislation? Very interesting word, right? Judiciary is making a law. Judicial legislation is antithetical, opposed to the doctrine of separation of power. Fair enough. So the question agrees on this point and mentions the statement that judicial legislation is actually directly opposed to the separation of power. Of course, judiciary cannot make a law. That's not allowed. However, in this context, we know very well judiciary making laws, etc., is violating separation of powers. Still, justify the filing of large number of PILs or public interest petitions, same thing, praying for issuing guidelines to executive authorities. I hope you understood the question. The question says, yes, judicial legislation, judicial governance is bad. It violates separation of power. But still, you please justify. Justify the filing of PILs, seeking the issuing of guidelines to executive. Despite the point that PILs are wrong, you please that judicial activism is wrong, justify it. So in this situation, introduction, basically the question is very simple. You have to talk about the issues of activism, talk about advantages and give examples. Introduction, talk about activism, but use the word judicial legislation. In bracket, write activism. Okay, define it, explain it. In the body, first paragraph, write the challenges, not the advantages. First, the challenges, some wrong things with examples. Second, then write need plus advantages. Why do we need this? And give examples. And then finally, in the conclusion, mention these points that there should be no judicial governance. I mentioned all these words, phrases right now. Exercise restraint, prevent overreach, etc. So this is there. You can also add the diagram in between. So this is how you answer this question. As I said, you can now address any kind of question that comes from activism, overreach, PILs, etc. The only thing is you should remember all these points and these examples. At least for the next 3-4 years, it's done and sorted. Okay. One more question. The most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with help of relevant case laws. Simple. Again, same thing. Here, you have to not write a generic advantage of activism, but write specific benefits of activism on environment. So, again, the same thing in the intro, write about how activism or what is activism, the source, Article 142, how it has helped in the body, mention the importance, keeping in line with the question, that is environment, and then give examples. We have discussed the examples earlier of PILs on environment. And once you are done, mind you, it's a 150-word question only. So don't write too many words. Don't describe too much. Relevant words only. And then again, conclusion, same conclusion. However, the court should also exercise restraint and not cross the boundary. So every such question will have the same kind of format. It is just that what kind of, or what will be the order of arranging those things is going to be different. But the points will be the same. Okay, now coming to tribunals. Last element under judiciary is tribunals, part 14A, article 323A and 323B. We only have 2 articles under tribunals, and the concept of tribunals comes from, see, the word tribunal is mentioned in the constitution, but the context, the meaning was not there. So finally, through the 42nd Amendment Act, we added the concept of tribunals on the recommendation of Sardar Swan Singh Committee. That's there. So, what exactly is a tribunal? See, tribunal is a quasi-judicial body. A quasi-judicial body. Now, what is a quasi-judicial body? Quasi means semi, partial. So, tribunals are basically an example of a partially judicial body. Not completely, partially. So, quasi refers to semi or partially. Now, when it comes to this quasi judicial body, how do we define it? I mean, such bodies are those whose functions resemble the functions of an ordinary court of law. Meaning what? They also conduct hearings, they also make findings of facts, they also apply governing laws of the country, and they also draw conclusions. The end result is that your task is to settle disputes. That is your goal. That is what is a quasi judicial body. There can be various examples. Sometimes it could be a statutory body, NHRC, the National Human Rights Commission. That's a classic example of a quasi judicial body. Then sometimes there are regulatory bodies. Regulatory. Regulatory refers to SEBI. So, when it comes to SEBI, the Securities Exchange Board of India, it's a regulatory body. Sometimes they can be constitutional. Example would be a finance commission. Finance commission is mentioned in the constitution. So, depends. Various examples of quasi judicial bodies. Okay. So, tribunal is a type of a quasi judicial body. But the whole point is, why do we need tribunals? What's the big deal about it? See, right from 1950s, we have realized that there is a lot of pendency, especially at the high court level. And we need at least certain bodies that can have proper formal hearing, right? And those bodies can be restricted to certain areas of expertise. So if we have an alternative structure, I'm not trying to replace judiciary. I'm simply saying judiciary is overburdened. Now, when judiciary is overburdened, if I could create a separate body, just like a judicial body only, but it will be given specific task, some expertise, some experts there, they could deal with certain kinds of matters, and they would largely give awards also, just like judiciary, and their delivery of justice will be cheap, quick, fast. Why? There will be no need to follow any kind of rule regulation, no Indian Evidence Act required, no hiring of lawyers required. You can come, get your case resolved, go home. That's the concept of tribunal, right? So, tribunals are authorities outside the court system which interpret and apply the laws when acts of government are challenged through formal suit. Suit here does not mean the suit you wear, suit means case, or other established methods. Regular courts are those where you do the same thing. You are finding facts, but in a controlled manner. Why? Because regular courts have to follow rules, regulations, Indian Evidence Act, CRPC, CPC, all these things have to be followed. But for tribunals, you don't have to follow such things. It's very easy for tribunals. Why? Because tribunals are not courts of law. They enjoy some powers of a civil court. They can call people to be a witness, number one. They can ask for any document to be presented in front of them, such kind of things. They are free from Indian Evidence Act, Code of Civil Procedure. No need to get trapped in all these rules, regulations, right? Free. All they have to do is simply natural justice. That's it. Ensure that delivery of justice is fair, ensure that both parties are given a chance to vent their frustration, and ensure that you give reasons for your awards. That is what is tribunal. In fact, tribunals don't even have judicial members. Some tribunals can have executive members also. So that is why tribunals are partially judicial bodies. And the beauty of tribunals is that they can review their own decisions also. Tribunals are allowed to review their own decisions. Okay, so that is all as far as the basic information is concerned. But then why do we have tribunals? As I said, number one, governance has become technical. Courts may not be experts in all these things. So, simple example, NGT. NGT is a tribunal called National Green Tribunal. NGT. You can Google for the full form. National Green Tribunal. It was formed under a law called NGT Act 2010. Now, what is the task of NGT? The task is to implement certain kind of laws, right? And ensure that the environment is clean. This is a technical kind of matter. Let the NGT have experts in the field of environment. They may be in a better situation or position to give such kind of verdicts. Or TDSAT, Telecom Dispute Settlement and Appellate Tribunal. Again, you can Google search for the full form. Telecom Disputes Settlement and Appellate Tribunal. So, some basic things like say call drop. Call drop is happening. Now, there can be a genuine concern on your side. Why are call drops happening? But there can be a technical issue also of call drops. Now, when it comes to judiciary, they may not understand all these mobile networks, star networking, etc. But somebody who is an expert in the field, if he is a part of this tribunal, he or she may have a better understanding and can understand what the telecom company is saying, why are call drops happening. So they may give a more nuanced, a slightly better verdict or an award compared to a court, which may not have understanding. The court will have to do one thing. The court will have to simply ask, form a committee, give me report. And then committee is formed, report is submitted, judge has to read the report, wastes time. Why not give this task to a separate body of experts? Secondly, as I said, no need to hire a lawyer, no rules, regulations, just come there, represent yourself, that's it. It will be inexpensive, it will be quick, and when decisions and awards are being given, meaning some kind of dispute is being resolved. Otherwise, these disputes would have gone to courts only, mostly high courts only. So it is also unburdening the already overburdened judiciary, providing a sense of relief to ordinary courts. That is, I mean, these are the factors as to why we have tribunals. Okay. Now, as far as tribunals in India are concerned, as I said, in the constitution, you will find the word mentioned there, tribunals, under two articles, 136 and 227. But the constitution never defined tribunals or gave them any kind of status or position. It has just been recognized that such a word exists. It was only in 1976, after the 42nd Amendment Act, that we inserted a separate part 14A and two articles, 323A and 323B. Based on these two articles being added, we allowed the parliament and the states to create tribunals. So basically, Article 323A allows the parliament to create tribunals for administrative matters. What do you mean by administrative matters? Administrative matters refers to matters like service conditions, service records, etc. Right? Promotions, postings, transfers. These are called administrative matters. Okay. Second is Article 323B. Tribunals can also be formed for other kind of matters. What will be other matters? Uh, Examples could be taxation, environmental issues, land reform. Let's write some examples. Taxation for environment, land reform. So these two articles said that tribunals can be formed, can be constituted. So basically 323A and B does not create tribunals. It asks or allows the parliament to create tribunals in future. That is the task. Okay. So this was done by Indira Gandhi, and later on in 1985, when Rajiv Gandhi was in power, he said, if my mother has made some changes, I should make some tribunal. And finally, because under 323A, the parliament by law can create some administrative tribunals. So a law was passed called the Administrative Tribunals Act of 1985. This was under provisions of Article 323A. Okay. Sushri, I think you know Article 136. It is SLP. Same goes for 227. It simply means that the courts can take up any kind of matter against any or any award which has been given, any judgment which has been given by any court in the country. The High Court and Supreme Court can take up such cases. SLPs, remember SLPs? That was Article 136. Anyway, now Administrative Tribunals Act creates three different kinds of tribunals. One is CAT at the central level, CAT, Central Administrative Tribunal. This CAT is meant for what? Central government employees. So all of you sitting here who will clear the examination of UPSC will be central government employees, and all India services officers will be sent to various states. Let's say you are an Indian revenue service officer. You are a central government employee. So what is the purpose of CAT or SAT? The purpose: deal with disputes or complaints with respect to recruitment and conditions of service. Meaning what? If in future, God forbid, it should not happen, let's say there is some problem with respect to your remuneration, your salary. Say in future your pension is stopped, or you are not given retirement benefits, your promotion has been delayed, or maybe your retirement is being expedited, etc. In all these cases, if you face any kind of problem in your service, right, and you feel you have been wrongfully removed from service, you have been wrongfully suspended, etc., you can always approach CAT if you are a central government employee, and you can approach SAT if you are a what? State government employee. So that is a difference between CAT and SAT. Now, sometimes you also have the provision of a common service. So, two or more states can also have a joint public service commission, right? Like in 1966, Punjab and Haryana had it. So, in that sense, if there is some joint service, then you can also have a JAT, for two or more states. So, if you are an employee serving under multiple states, then of course JAT, that's there. So, this is a concept of administrative tribunals. Now, one very important element that you have to understand, this body CAT does not take care of armed forces. Why? Because for armed forces, we have a separate tribunal called Armed Forces Tribunal. Okay. So, just to add here, armed forces not included. There is a reason for it. Armed forces does not or requires to be dealt with differently. Why? Because employment in the armed forces is not the same as employment in the civil services. Because say, let's say you are a government employee, very simple example, and you don't come to the say office, you are absconding. Okay, what happens? Nothing happens. You'll be replaced, removed from service. But imagine you are an armed forces personnel, some Jawan fighting on the border, and then you are absconding. That can actually cause a security concern for the country. So the service conditions, etc., for armed forces personnel is very different from a regular civil servant. That is why they have to be treated differently. Their cases are different, the situations are different, right? And hence the tribunals are different. Okay. Now, what is the composition of the CAT, SAT, etc.? So very simple. Every CAT and SAT and such bodies have chairpersons, vice chairpersons, judicial members, and administrative members. For qualification of chairperson, former or sitting judge of High Court. Okay, that's the chairman. Judicial members, they can be former or sitting judge of High Court, or any IAS officer who has been a secretary in the government of India for 2 years, or additional secretary in the government of India for 5 years. In which department? Department of Legal Affairs. So see, IAS officers can be members and they can be judicial members. So the ranking of IAS officers is like this. You have at the top secretary, then you have additional secretary, then you have joint secretary, then you have deputy secretary, and then you have under secretary, and then you have section officers, etc. So any IAS officer can also become a judicial member, and then CAT SAT also have administrative members. So who are they? Anyone who has been a secretary in the government of India or government of state in any ministry, any department for 2 years, or an additional secretary for 5 years. You can be an administrative member. That is a membership. Then appointment. Now, before I discuss the appointment and term of office, I have to clarify these are old provisions. Now you will say, sir, why have you made old provisions? Why not updated it? Are the slides not updated? They are. We'll come to it shortly why I have still mentioned the old provisions and why I'm teaching you the old provisions. So appointment to be done by the president in consultation with CJI for CAT and in consultation with the governor for SAT. What's the term of office? Chairperson's term of office is 5 years or 68 years, whichever is earlier, and member's term of office is 5 years or 65 years. Okay, and once you retire, no future employment. under Government of India, Government of State, after retirement. No future employment. Conditions of service, same as High Court judge, same salary, same allowances. And how can the members be removed? Now, here the removal is not done by Parliament, not by Parliament. If the President receives any complaint against any member of CAT-SAT, the President will ask the Supreme Court to conduct an inquiry. If the Supreme Court finds the person to be guilty, Supreme Court can ask President, sir, remove him, and the President will remove the person. So the removal here is not through voting in the Parliament, but through inquiry by Supreme Court and on Supreme Court's recommendation. That's the difference. Okay, no parliamentary voting takes place. Okay, just a small point to be made here. Originally, tribunals and their awards could only be challenged in the Supreme Court. They could not be challenged in High Court because the purpose of tribunal was to unburden the High Courts. So if you can allow the challenge of tribunal awards in High Courts only, then what's the point? But in 1997, in the L. Chandrakumar judgment, Supreme Court said, no, 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 no. High Courts are courts of records. How dare you? How dare you make a law which tries to, bypass the High Courts? Tribunal awards can be challenged in High Court and Supreme Court. So, the awards of tribunals can be challenged in the High Court, then appeal in the Supreme Court, or appeal in the High Court and then Supreme Court. So, and now for all the tribunals, till recently, for example, there was a tribunal called NGT. Now, NGT is the National Green Tribunal. National Green Tribunal, the law was called NGT Act 2010. In the law, it is clearly mentioned that the awards of NGT cannot be challenged in High Court but only in Supreme Court. But just recently, Supreme Court has passed a judgment saying no, even NGT awards can be challenged in High Courts. Awards can be challenged in High Courts. Yes, awards means, Chanabaswa, awards means decisions. Mandeep, they are drawing conclusions. Oh, acha, previous question. Niti Aayog is not a quasi-judicial body. What is Niti Aayog's decision? It's a recommendatory body. It gives recommendations. So it does not pronounce verdicts and all. Okay. Drawing conclusions refers to settling disputes, right? I am here drawing a conclusion that very intellectual question asked by you. That is not making me a quasi-judicial body. So drawing conclusions to solve disputes. Okay, that is it. So this is it. Now coming to L. Chandrakumar. So this judgment is also seen by a lot of people as a problem that we wanted to unburden the judiciary, especially High Courts. And again, you are challenging the High Court, the awards of tribunals in High Courts. What's the point? But anyway, Supreme Court says High Courts are court of records. How dare you bypass them? And they are right also. High Courts are also courts where constitution is interpreted. So bypassing them is also a big problem. That's it. Anyway, so coming now to advantages, some benefits, some nice things, good things about tribunals. So tribunals have flexibility of procedure. As I said, no rigid procedures, no evidence ordeals, no need to follow Indian Evidence Act, no need to submit evidence beforehand, nothing is required. No CPC, etc. to be followed. Principles of natural justice. Those three elements have to be followed. That's it. They are cheap, they are quick, time effective, cost effective. So efficiency at dispensing, providing justice enhances, of course. Then they are actually unburdening the judiciary also. And most of these tribunals have experts as members. So, specialization through expert involvement, which enhances the quality of awards or judgments or verdicts, right? Awards are verdicts. But then there are some problems. What are the problems? So you will be surprised to know, see, India is a very populated country. Okay. So don't think that, oh, we have created tribunals. In tribunals, there is no delay. There is delay everywhere. There is delay everywhere, even in tribunals. If you look at the situation of some tribunals, for example, CAT only, CAT had roughly 45,000 pending cases. 45,000 pending cases, meaning 45,000 employees who have filed some case. Maybe their pension has been stopped, gratuity is not being given, they have been transferred uselessly, they have been suspended uselessly, and they are waiting. Or Railway Claims Tribunal, RCT. Railway claims, basically, if let's say you book a ticket and you are waiting on one stop, and a train comes, does not stop there and goes, and you are still waiting with the luggage. Now that's something where the railways has to return the money, right? With some penalty also. If you have such kind of issues, where do you go? Okay. RCT, or the Railway Claims Tribunal, has 46,000 pending cases. Or income tax. Income tax appellate tribunal. If you're not happy with the income tax tribunal's decisions, you can go to ITAT, Income Tax Appellate Appeal Tribunal. 92,000 cases are pending there. Or Debt Recovery Tribunal, DRT, Debt Recovery Tribunal. 78,000 cases pending there. This is a situation of pendency. What to do? So much of population. Pendency here, there, everywhere. Okay. Now, number two. One more thing. Vacancies. Vacancies are also there. I mean, just to give an example of vacancies, in CAT, out of 69, you have just 42 people, right? 27 seats are vacant. So that's the beauty of our bodies. Vacancy will be there everywhere. I mean, even in the IAS officers, vacancy of 20% is there. But are the people, is the government increasing the number of seats? No, they are only decreasing number of seats, right? Then violation of separation of power. So some people also say, no, you are violating separation of power. How? Very good example in this case is of NGT, National Green Tribunal. NGT is a body which makes rules regulations like the legislature. It also ensures that those rules regulations are followed properly, right? If you don't follow those rules and regulations, NGT can also punish you with fine up to 5 crore rupees. Jail sentence can also be imposed by NGT. If you don't follow the NGT awards, it is not just up to 10 crore rupees. Jail sentence can also be imposed up to 3 years of jail sentence if you don't follow the NGT decisions. They can also punish, just like judiciary. Okay. Are we not giving all these functions, which ideally should be with separate bodies, to one body only? Violation of separation of powers. Then independence is compromised. Look at the example of CAT. Who are the members in CAT? IAS officers. Sushri, executive? Executive? Oh, we discussed in the very first class. Legislature, executive, judiciary. Executive refers to the government, the ones which make policies, programs, welfare policies, etc., implement the rules, regulation in the country, right? So that's the point of executive. How NGT acts as executive? Oh, I had a small stroke only. Okay, NGT acts as an executive by implementing the rules, regulations in the country. For example, NGT, see, there are some, again, this is a topic that will be covered thoroughly in your environment classes, but just to give you a point, NGT implements certain laws. Water Prevention and Control of Pollution Act 1974. This law is implemented by NGT. Forest Conservation Act 1980. This law is implemented by NGT. Air Prevention and Control of Pollution Act, that is 1981. This law is also implemented by NGT. Public Liability Insurance Act 1991, I believe. This law is also implemented by NGT. Biological Diversity Act, this law of 2002 is also implemented by NGT. I mean, there are only a few laws. I believe one law which NGT does not implement is the Wildlife Protection Act of 1972. And one more law is the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Rights Act. So barring some laws, most of the laws are implemented by NGT, the National Green Tribunal. So that is how they perform the task as an executive. Okay. So as I was saying, independence is compromised. How? Look at the members of CAT, IAS officers, retired IAS officers, government employees. Who goes to CAT to complain? Government employees. If I am an IAS officer, I know that government can help me, make me governor somewhere in future, give me the post of election commissioner, give me the post of CAG, etc. Do you think I would want to give a judgment against the government to help some government employee? No, 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 no. My loyalties may largely be towards the government. That gets compromised. That is why independence is compromised because of membership. Then allegations of corruption. Rampant corruption in tribunals everywhere. I had read recently, there's this person who made this remark that he was being asked to pay money by one CAT member to get his pension released. So his pension, sorry, his gratuity had been stopped for certain reasons. I think there was some issue with his birth certificate date, and because of that, his gratuity was not being released by the government department he had been working in after retirement. It was amount of some 20 lakh rupees, and he had filed a case. And one CAT member said, "I'll give the judgment in your favor, 2 lakh rupees, 10%," and that is what he claimed. So this has been the situation, right? Sadly. Then lack of infrastructure. I mean, that's very poor. To tell you frankly, we have only 17 CAT benches. And mind you, awards given by CAT or verdicts, judgments given by CAT can be challenged in High Court. We have 17 CAT benches, we have 25 High Courts. I mean, how can you have more bodies at a higher level and less bodies at lower level? And that too vacancy in CAT. And not just this, their functioning is very, very opaque. Websites, you try to go to the websites. Websites are routinely unavailable. Sometimes for some tribunals, there's no website only. Sometimes not responsive, unable to open, not updated. So this is how they're functioning. Completely opaque manner. So this is what, or these are what are the problems in the working of the tribunals, right? Now, to bring about certain changes, the government passed a law. Initially, they brought an ordinance, and then they passed a law. This is a law called Tribunals Reforms Act 2021. Interesting thing about this law is that this law is currently challenged in the Supreme Court. Now, what is the reason for challenge, etc.? We'll discuss it once we come back after the lunch break. Let's take a break. be back at 2, and then we'll discuss further the topic tribunals. I think maybe 20-25 minutes are left here, and then we'll move on to elections and the RPA 1950 1951. Shalu, how lack of infrastructure? I just said lack of infrastructure, meaning some basic things like existence of CAT. We have so many government employees. We just have 17 CAT benches across the country, right? Their websites don't function properly. There is vacancy in CAT, right? You go to their buildings, you won't find people there. Staff is not adequate there. That is called lack of infrastructure only. How will they function? Okay. Ranjan, High Court is the high authority. If my decisions can be challenged in front of some other person, then that person becomes a high authority. No, Abhijit. See, arguments against activism. No. There is no argument against activism. It's all arguments against overreach. See, if you behave properly, let's say I only interfere when required, there's no problem. But if I interfere unnecessarily, that's the problem. That is why I'm constantly saying restraint, restraint. So, necessary evil would be slightly harsh. And yes, of course, it is necessary because the government and the parliament will always somehow fail to perform properly. So they may have to interfere. The limits should be decided by them only. So that would be a slightly harsh statement to make. Rani, of course, tribunals are not defined in the constitution. You just find the word tribunal mentioned. That's it. Nothing else. Okay, let's take a break, guys. After the break, we'll come back and we'll discuss further the remaining topics. Sweta, appointment. Appointment is to be done by the president on the advice of the Chief Justice for CAT and the Governor for SAT. And please wait for appointment because the new Tribunal Reforms Act has made some modification in appointment. So I'll have to also draw some parallels. We'll do it after the break. Okay. Break, please. Break till 2 p.m. Please enjoy. Eat well, have lots of tea and coffee, and please be awake for the next session after the break. Break, please, guys.